Okay, we're back. Let's start off with Rule 41. Rule 41, involuntary and voluntary dismissal. 41 means involuntary dismissal, which can be permitted for a violation of the rules, can be permitted for failure to prosecute your case. Typically, it's going to be for a violation of the rules. For example, a failure to state a claim, right? Now, involuntary dismissal is going to typically be with prejudice. You know, it's an adjudication on the merits, unless it's one of the carved out bases, right? Lack of jurisdiction, failure to join a rule, a 19th party, and so on and so forth. The court can, of course, indicate exclusionary effect, and oftentimes courts will. I'll spend a little bit more time talking about Rule 41A, voluntary dismissals. Voluntary dismissals on Rule 41A, parallel amendments under Rule 15. In other words, you can do them unilaterally, you can do them by consent, or you can do them with the permission of the court, right? Now, regarding these voluntary dismissals, if you do it by yourself, that's called a notice of dismissal. I call that NOD in our fact pattern, notice of dismissal. That's the unilateral notice that you simply file with the court, and that has the effect of dismissing your action. As long as there's still time to do an NOD, you can do it. You don't need permission from the other party or the court. Let's see if that shut down our video camera. Hopefully not. Hello. Well, the alarm's always blaring in this class. You think I'd be a tornado or a hurricane every day in this class, right? All right, video cam is on. To continue. All right, guys. All right, to continue. What's that?
It's going up.
Ah.
It's going
All right, well, I really don't need it. The whole thing is rebooting. Okay, let's give it a chance to reboot.
I wonder what happened.
All right, I don't need it. Well, no, this is on. Oh, goodness sake. All right, I'm going to ignore this and I'm going to continue rather than spending time. All right, if there's a notice of dismissal, you can file the notice of dismissal as long as the defending party hasn't served an answer or motion for summary judgment. Okay? That doesn't include a pre-answer motion. A pre-answer motion is not an answer. A pre-answer motion is not a motion for summary judgment. There's some aberrant case of law out there that the case book notes, but that case of law has been widely criticized. All right? So as long as there's not been service of an answer or an MSJ, motion for summary judgment, you can unilaterally dismiss your lawsuit. Now, if it's too late for you to dismiss your lawsuit unilaterally, you can nonetheless get a dismissal voluntarily just by asking the other side, right? Get them to stipulate, all right? Now, suppose it's too late to do notice of dismissal, it's too late to do stipulation of dismissal, or the other side rather won't agree to a stipulation. You can ask the court, right? By motion, hey court, will you please allow me to dismiss my claim? And then it's up to the court. All right. Regarding these first two types, notice of dismissal and stipulation of dismissal, we have to be concerned about what I call the two-shot rule, right? What happens if you file dismiss, file dismiss, file dismiss, file dismiss? It'll be really unfair to the other side, right? They have to keep doing investigations, they have to keep answering, it's expensive, it's time-consuming, it's harassing. So what Rule 41A says is that once you dismiss voluntarily once, all right, then any second dismissal of the same claim will act as an adjudication upon the merits if that second dismissal is by notice of dismissal. That really is the essence of the two-shot rule. Think of the first step of the analysis being, was there a prior voluntary dismissal of that same claim in a previous case in state or federal court? The answer to that is yes. And the second step asks, is there a second dismissal by way of notice of dismissal? All right, so for example, dismissal number one is a stipulation of dismissal in state court. The stipulation is silent on whether or not the stipulation is with prejudice or not, and since it's silent, it will not have prejudicial effect. permitting refiling in lawsuit number 2. Let's say lawsuit number 2 is dismissed unilaterally by the plaintiff by notice of dismissal. Both suits were for the same thing. All right. Well, we have a prior dismissal that's voluntary, and a second lawsuit for the same thing, which was dismissed unilaterally by the plaintiff by notice of dismissal. The second dismissal, because it's by notice, acts as an adjudication on the merits. In contrast, suppose the second dismissal was by stipulation and dismissal by the same defendant. This will not be an adjudication on the merits. Why? Because the defendant could have helped itself, right? The defendant could have said, hey, I'm not agreeing to the stipulated dismissal unless you agree that it's one that is with prejudice, right? So what the rule does is it makes the second dismissal have dispositive effect, if and only if it's by notice of dismissal. Because remember, the notice of dismissal is unilateral. It's by the plaintiff. The plaintiff doesn't have to ask the defendant, doesn't have to ask the court. So to prevent abuse from NODs, the court has, Rule 41A has the 2 shot rule. All right. Let's move on to summary judgment. And here I have some handouts for you that are hopefully helpful. I encourage you to go back and look at them again. The basic gist of Rule 56 is that we don't need trial. We don't need a fact finder. If the material facts are not in genuine dispute, who needs a jury? Or who needs the judge to find the facts? If the facts aren't in dispute, then just allow the judge to decide the case as a matter of law. So for Rule 56, we have to show, the movement has to show there's no genuine issue of material fact, and entitlement to judgment is a matter of law. Now, here I want to refer you to the handout, and I'm not going to go into extensive detail on the handout, because the handout does really, I think, hopefully nice job of laying out the various scenarios. Instead, I'll speak more from the big picture standpoint. Then you can look at the handout and use the kind of big picture ideas to guide you. At trial, the burden of persuasion is going to belong to the party who's asserting a claim or a defense. So if P sues D for negligence, it's the plaintiff who's going to have the burden of showing that the defendant breached the duty of care causing damages, right? Equally so, in that same suit, if the defendant asserts the affirmative defense of comparative negligence, then the defendant is going to be the one that has that burden of showing that the plaintiff breached the duty of care causing his own damages, right? So you have to ask, at trial, who would have the burden of persuasion, right? That's what you do at trial. But Rule 56 is about the burden of production, all right? But that burden of production is the burden to convince the court that there's no need for trial because the issues, the factual issues that are material to the relevant law are not in genuine dispute. Now, what those facts are going to be is going to depend on the relevant law, right? So, for example, on my website, I have one of my favorite old study essay questions, which involve Vinnie Barbarino and Arnold Horseshack. You guys know who those guys are? Yeah. Wow, I'm getting old. Vinnie Barbarino? You got web computers, look it up. Welcome back, Kotter. That's right. A very young John Travolta in a TV show in the 70s, very popular. Watching Travolta's career. So Travolta's Vinnie Barbarino, and he sued by Arnold Horseshack for stealing a song, right? And in the fact pattern, I give you the governing law for copyright infringement, right? And what you got to do is look at the governing law and determine whether or not you need to have a fact finder, such as a jury, decide each of the elements, right? Or if the facts are either conceded or stipulated, or there's no genuine dispute, then you don't need a fact finder, right? That's what summary judgment's about. It. It's like 12b-6, but at a different stage in the litigation. It's a gatekeeping function. And the party that's moving for summary judgment is the one that has the burden of production, of convincing the court. We don't need to have a trial because the facts just aren't in dispute. Well, keep in mind, he sues D for negligence, right? Well, the plaintiff could move for summary judgment on her own claim, right? Or the defendant could move for summary judgment to seek dismissal of the plaintiff's claim. Whoever the movement is the one that's going to have that burden of production of convincing the court that there's no need for trial, right? Now, how to show summary judgment is going to depend what position the movement is. Is the movement somebody who is moving on their own claim or defense? Or in contrast, is the movement somebody who's moving to get rid of somebody else's claim or defense? Well, if I'm moving for SJ on my own claim or my own defense, then I got to show the court that I'm going to win on that claim or the defense. That a reasonable jury must find in my favor. We don't need a trial because I win on every element, all right? It can be done, but that's hard to do. I just land and call it proof of all the elements, summary judgment, right? The more common scenario for summary judgment is when somebody is moving for summary judgment on somebody else's claim or defense. That's like in Celotex, right? Or like the case in the book, right? Somebody sued you, now the defendant's moving for summary judgment, get rid of the plaintiff's claim. Well, you know, here's a tripod over here, right, with the mic on it. What happens if we break off one leg of a tripod? The whole thing falls down, right? A three-legged table can't stand on two legs. And it's the same thing in summary judgment when a defendant is moving for SJ to get rid of the plaintiff's claim. So, for example, if the plaintiff is sued defendant for negligence, well, then the plaintiff's got to show duty, breach, cause in fact, and proximate cause, and damages, right? Well, duty is determined by the court, so I won't address that. But suppose the plaintiff has absolutely no evidence whatsoever that the defendant breached the duty, right? Can the defendant, can the plaintiff win?
No.
Yeah. If the plaintiff has no evidence of breach, all right, well, let's assume it's not a res ipsa loquitur fact pattern, then the plaintiff just can't win. So, the defendant, I'm moving for summary judgment, well, all I have to do is meet my burden and convince the court there's no way the plaintiff is going to be able to show breach. And if that's the case, then we don't care if somebody hit the defendant and that car accident caused the damages, because with this element gone, with that one leg gone, the plaintiff simply can't win, right? So that can be met in a couple of ways. I could put forth my own information. I'm the defendant. I could put forth affidavits. I could give the court copies of deposition transcripts. I could give the court documents and videos and all of that, right? That would be me, the defendant, meeting my burden by putting forth materials, right? However, Celotex gives us another method. When I'm a defendant, moving summary judgment on the opposite side's claim or defense, right? I can just point out to the court. I say, hey, court, look, plaintiff took all these depositions. Plaintiff took all my documents, looked at all of them, and plaintiff still has nothing, right? And that's the Celotex method. Instead of putting forth your own materials, instead, the moving party simply points out to the court, shows the court that the non-moving party has nothing, right? They can't just make that bold assertion. Instead, you should be pointing out, well, there's been all this opportunity for discovery, and this is what we did, and the plaintiff still has nothing, all right? That's another way a defending party can move for summary judgment on the plaintiff's claim. But of course, the moving party can combine these methods. So a moving party might say, here's my affidavit, and where I say that I didn't do it, and here's my plane ticket showing I was out of town at that time. By the way, and that's the method of putting forth your own materials, right? And then combine that with the Celotex method. And in addition to that, Your Honor, the plaintiff's got nothing, even though the plaintiff's taken all this discovery, right? And that's actually how things oftentimes work in the real world. What else to note about summary judgment? Again, I'm not going to get into every last detail, right? You know, affidavits have to be by a person who's competent to testify. It's got to be based on personal knowledge. Materials used for summary judgment either have to be admissible in court, or if they're not admissible in court, must be something that can be reduced into admissible form, right? Is there anything else that I should be noting about summary judgment? I think there's always more detail, but no? All right, let's move on. All right. Oh, and just last reminder with summary judgment, do look at that handout. I think in light of your recently completed project of little writing, hopefully combined with what we're saying right here in class and the handout, that'll give additional light to summary judgment. Yes, that's it. All right. Next, right to jury trial. This one's going to be relatively quick. Seventh Amendment. Right to jury trial in cases of, this is $20 or above, right? It doesn't say above $20? It's $20 or above, right? 20 or more, okay. Cases at law valued at $20 or more, there's a right to jury trial in the federal system. All right. Now, the first clause is the preservation clause. That's the one we discussed in detail. That right shall be preserved. Well, preserved, what does that mean? That means that we have to look back at what's going on in England itself back in 1791 when the Seventh Amendment was ratified. All right, well, that's problematic, right? Because it's hard to tell sometimes what was happening in England. So we had that one handout where I showed you from the Terry case. Terry case wasn't assigned, but I showed you how the court struggled and fought bitterly amongst itself on, well, what was going on in England regarding various causes of action and what was the best cause of action. Judges don't make good historians. So let's talk more meaningfully. First, the Seventh Amendment right only applies in federal court, not in state court. State courts are not bound by the Seventh Amendment. If there's a jury right in state court, it's because the states themselves have allowed it. Second, with the jury right, you have to consider what kind of claim it is, right? So claims at law have a jury right, claims at equity do not. Now, if the cause of action existed back in 1791, then the case is really very simple, right? But lots and lots of causes of action that exist today are modern statutory inventions, ones that didn't exist at law or equity in 1791. So what the court does here is that two-step analysis we remember from the cases and from our discussion and from the handouts. There's a handout on the website. You should look at that one too. And the first step is to look at the historical analog. In other words, even if the cause of action didn't exist in England in 1791, what's the best historical analog? Second, look to the nature of the remedy sought. All right. Now, regarding the analog, that's a little hard to test you on, right? Because you guys aren't legal historians, right? So maybe I'm telling you this more so you know what the steps to test are. If they have a question on it, that I would give you sufficient facts that you can analyze it, right? But you're not legal historians. The Supreme Court's not particularly good legal historians either. The idea here is whatever's the closest analog from 1791 in England, well, was it something heard in courts of law? If so, jury right. Or was it heard in courts of equity? If not, then maybe not jury right. So the court tells us the most important analysis is not step one, rather step two, the nature of the remedy sought. So if the remedy sought is legal, then that very heavily suggests jury right. And it's equitable, very strongly suggests that it's not. But it gets even more complex than that, right? Because we have cases noting that things that were available in equity courts, like in accounting, still had a jury right. That was the Dairy Queen case, right? So in other words, equity didn't mean equity. Because in accounting, available in equitable courts of equity, was ultimately about obtaining money, right? So in Dairy Queen, the court held there was a jury right. And sometimes money doesn't mean law, right? So we have the discussion in the was it Curtis versus Luther? Curtis versus Luther, thank you. Where the court notes that, well, some types of monetary relief, such as back pay, might be characterized as equitable. So what does that mean? That makes it kind of hard to do on like an essay question, right? because it's a level of knowledge of legal history that is kind of going to be beyond what I can give you in a fact pattern. However, stuff like this I could test you in multiple choice questions, so please do know it. I'm not going to give you an essay question on this aspect of the Seventh Amendment. I don't think that would be particularly fair. Okay? But I mean, you still need to know it because I can test you on it in other ways. So, you know, among other things, know the two-step test. Here's another thing that I think you ought to know is the abrogation, getting rid of the so-called cleanup doctrine, right? Under the cleanup doctrine, to the extent that a court of equity could hear equitable claims, incidental monetary claims, then it could hear both, and there would be no jury trial, right? Well, in our modern court system in the United States, in our modern federal court system, you know, we don't have separate courts for equity and law. We have this one combined court system in the federal system, and we only have one form of action. It's a civil action, right? So under Rule 18A, if you want to sue somebody, you can sue them for all sorts of unrelated claims, and you can seek all types of relief. So, for example, I sue you for copyright infringement. I seek damages. I seek attorney's fees. I seek an injunction. I join in a claim for my stamp collection. I want you to return it. I want specific performance. I also sue you for trespassing on my lawn. I want an injunction against you, and I also want damages because you stepped on all my flowers and they're ruined. Okay? See what I mean? A whole bunch of unrelated stuff, a whole bunch of equitable and legal claims, and all of that. Well, what do you do when you're in the federal court and somebody's seeking stuff that in modern day federal court, some of the stuff would have been equitable, no jury, and some of the stuff would have been legal, right, jury. And the Supreme Court explains this to us in a Dairy Queen when it cites the early case of Beacon Theaters, where it tells us that there is no more cleanup doctrine, that if you have a case involving both equitable and legal issues, you let the jury decide the legal claims and the legal issues first. And then those issues are decided. And if there's overlap between those issues in both legal claims and equitable claims, then the court is going to be bound by the decisions of the jury. So really, as the example of this is the case of Beacon Theater itself, right? You have the plaintiff sued the defendant seeking some sort of declaration that a contract was not in restraint of trade, right? Or that the defendant counterclaimed seeking a claim for antitrust, seeking money. All right. Well, because the cleanup doctrine is bye-bye, it's gone, we decide the antitrust counterclaim first, have the jury decide that, right? And then those findings are going to bind the judge, when the judge then decides the main claim, seeking a declaration that the contract is not in restraint of trade, right? Now, the findings down here might determine the finding up there, or the judge might have to make some additional findings up here. But what the judge cannot do, the judge can't decide the claim first, right? And the judge can't redecide things that have been already decided by the jury. Now, Beacon Theaters, as discussed in Dairy Queen, does have kind of like a exception built into it that in exceptional circumstances, maybe we would decide the equitable issues first, but the court doesn't tell us what those exceptional circumstances would be. And I can't even imagine what those circumstances would be. So as a basic rule, you decide the issues at law first before the equitable issues. All right, let's move on. I think that's all I'm going to say on that. So now we move into Rule 50 and Rule 59. So now we're into trial and post-trial motions. We're getting there. We're getting there. We're getting towards the end. All right, trial and post-trial motions. All right, it's trial. We have the fact finder. And here we'll talk in terms of jury. So if we have the jury, and during trial, we can have Rule 50A motion for judgment as a matter of law. That's also known as DV, directed verdict. When you move to directed verdict, all right, you have to specify the grounds for the motion, all right, and make the argument why you, the moved party, are entitled to judgment as a matter of law on that issue. You can't move for directed verdict until the opposing party has been fully heard on that issue. All right? So, for example, the trial starts, and before the plaintiff even starts calling witnesses, the defendant stands up and says, I move for a directed verdict. No. The plaintiff hasn't even called any witnesses yet. The defendant's going to have to sit down and wait until the plaintiff is put on the case. All right? Well, once a party's been fully heard on a particular issue, then the opposing party can move for directed verdict. Now, if the motion is granted, then that is going to determine that issue and may even result in dismissal of the case, right? So judges are kind of hesitant to grant directed verdicts during trial because the judge might think, well, I tend to agree with the moving party, but let's let the jury decide. Hopefully the jury will do the right thing. And that makes the case much harder to appeal, right? Makes the judgment much more secure. Well, that's okay, because say you move for a directed verdict during trial and the court denies it, well, you still have the right to renew your motion for judgment as a matter of law after the trial. That's RJMOL, right? Also known as judgment notwithstanding the verdict, JNOV, judgment non obstante remittitur, or something like that. All right, that's the post-trial motion. Now, first, you can't move for a 50B unless you move for 50A at the proper time during trial. Second, you can't move on 50B unless the basis for the 50B was asserted in your earlier 50A motion. All right? But if both those elements are met, you did move for 50A during trial, and the 50B is for the same thing, then you can move for 50B after trial. And here, perhaps the court is a lot more likely to grant the motion. Now, if you move after trial for 50B, all right, you can also move in the alternative for a new trial under Rule 59. And that allows the court to decide one or both motions, perhaps one of them in the alternative. For example, the court might decide to grant judgment as a matter of law under Rule 50B, and then regarding Rule 59, give a conditional grant of a new trial. And that way, if on appeal the Court of Appeals says JNOV was improper, it can send the case back down for the new trial. Okay? Now, let's talk about the standards under Rule 50 and 59. This coffee has made a world of difference. Thank you both. Thank you. Coffee is especially good when you haven't had any lunch. Much quicker than that. All right. No, it's all like that. That would be for after the review session. All right. Standards. Well, Rule 50, and here I'm talking about 50A and 50B. First, the courts say that the standard for summary judgment is basically the same as the one for a JMOL and RJMOL under Rule 50, right? So, for example, court does not weigh evidence. Court does not assess credibility, right? In contrast, under Rule 59, motion for a new trial, the court can weigh evidence, and the court can assess credibility. All right? Other things to note about the standards. In federal court, the Rule 50 standard is usually described as being the substantial evidence rule. All right? Substantial evidence rule, among other things, means that the court can look at the evidence of the non-moving party, and the court can look at any evidence introduced by the moving party. All right? In other words, can look at all of the evidence introduced up to that point. All right? And what it will do is it will give credit to, well, I shouldn't say credit, it will consider the non-moving party's evidence, and regarding the moving party's evidence, it will consider it to the extent it doesn't contradict the non-moving party's evidence. But remember, you don't weigh evidence, you don't assess credibility, and looking at the evidence, the court asks whether or not we need a fact finder, right? Or put differently, Must a reasonable jury find in favor of the moving party? Not may, but must. Must the jury find for the moving party? Okay, so we can visualize it kind of like this. And here we have the chart in Glannon, which Glannon himself got from somewhere else, which is commonly used by Civ Pro professors. I don't remember the page number. Was it 1821 or something? Something like that. For some reason, the number, no, not 1821. We don't have 2,000 pages. 1221 is it? Oh, I don't know, but you know where it is. It's in the Rule 50 chapter. It's the one that looks like this, right? Here's 0%. Here's 100%. Here's the imaginary 50% line. And as long as the facts are somewhere within this range here, then the judge is just going to let the jury decide, right? But if we fall below this line, then JMOL will be appropriate for the defendant. Equally so for over here, the JMOL will be appropriate for the plaintiff. Okay? And this is where the standards make a big difference. So remember I said, federal courts generally use the substantial evidence rule. You can look at both parties' evidence. Some, not all, some state courts use the so-called scintilla test. The scintilla test would only look at the at the non-moving party's evidence. So if the defendant moves for summary judgment in a scintilla jurisdiction, then the court would only look at the plaintiff's evidence. And the cases here really illustrate how this looks, right? So imagine, for example, the Chamberlain case. Remember that case in the book? The poor guy that was, allegedly knocked off the train and run over by the train cars, and he really didn't have much in terms of evidence, right? Well, under the scintilla rule, imagine the court only looked at the decedent's evidence, right? Which was, there was this guy, his name escapes me at the moment. You guys remember? Okay, whatever. The only evidence the plaintiff has is a guy like hundreds of yards down the track that was looking at the trains, saw the cars going, turned around, wasn't paying attention, heard a loud crash, turns around, and then sees people screaming and running, and then sees the plaintiff has been run over, okay? He didn't actually see the accident happen, right? But he saw the cars close together, heard a crash, turned around and saw the guy who was unfortunately lying there dead. Well, based on that, we're over here. We're just to the right of this line, this point of no return, right? So in a scintilla jurisdiction, directed verdict should be denied, right? Looking only at the plaintiff's evidence. The plaintiff's case is really weak. Is it strong enough the jury must find for the plaintiff? No. Is it strong enough the jury could find for him? Yeah, based just on the plaintiff's evidence. The scintilla standard is we only look at the non-moving party evidence. All right? But we go in a substantial evidence jurisdiction, we can look at both. All right, now, in a substantial evidence jurisdiction, we can look at the plaintiff's weak evidence, and we can also look at the uncontradicted evidence of the defendant railroad of numerous witnesses saying these trains, these cars never touched each other, right? Well, guess what? Now we're over here, right? And a directed verdict would be appropriate. So that's our Rule 50 standard. Now, in contrast, Rule 59, motion for a new trial, regarding its standard, to elaborate on what I said a few minutes ago. First, a new trial can be sought on the basis of trial error. And we discussed some of the various examples of error. That might be erroneous jury instruction, or evidence was admitted when it shouldn't have been, or evidence was excluded when it shouldn't have been, right? Or misconduct, or lawyer misconduct, and so on, and so on, and so on. And here we have to think about, Rule 61, the harmless error standard, that error is not a basis for a new trial if it was harmless. In other words, the movement moving for a new trial has to show that the error was actually prejudicial, right? It actually had a real impact on the outcome. Well, that's the error basis for a new trial. The other one is against the weight of the evidence. And this standard is articulated in a number of ways: against the substantial weight of the evidence, against the great weight of the evidence, shocks the judicial conscience, blah, blah, and so on. All right? The basic idea here is not that the judge would have found differently, but that the judge feels that the jury's verdict is really aberrant, right? So in other words, I suppose getting back to our little table that I shouldn't have deleted, but here we go. Let's assume this is the range of what a jury can find, all right? Suppose we're right here. Now, if we're right here, a directed verdict or a JNOV would be inappropriate because we're just inside the line that indicates the range for reasonable jury verdicts, right? So Rule 50 order would be inappropriate. However, we're so darn close to this line, the court may feel, nonetheless, the jury verdict was against the great weight of evidence and decides to grant the motion for Rule 59, new trial. All right. Last thing on new trials is the difference between additur and remittitur. Remittitur is when the jury's come back and given a really high verdict, and the court feels that it's too high, right? So for example, P versus D for a minor injury, and the court awards $1 million to the plaintiff. And then the defendant moves for a new trial on the basis of shockingly high damages, right? Well, remittitur is the court saying to the defendant, hey, defendant, I'm going to grant this motion for a new trial unless you agree to reduce your damages down to whatever the court deems appropriate. And the book gives us some of the formulas used by courts, right? Well, remittitur is constitutional, says the Supreme Court, because the remitted, in other words, reduced amount, is still within the range found by the jury. So from the floor up to my hand is $1 million, and $100,000 is still within that $1 million. That's constitutional, doesn't violate the Seventh Amendment. Additur is the reverse, right? E versus D, the plaintiff wins, but the damages awarded are shockingly low. Now who's moving for a new trial? It's the plaintiff, not on liability, but rather on the amount of damages. All right, the plaintiff says, oh, I'm glad I won, but the amount the jury awarded me was shockingly low, and I want a new trial on the issue of damages. Well, in theory, additur would be the court saying to the defendant, you either increase the amount that you're willing to pay to X, or I'm going to order a new trial. However, in the federal system, this is not permitted because it would violate the Seventh Amendment. Why? Because here's what the jury awarded, say $100,000. The judge feels it should have been $1 million. Well, guess what? $1 million is not within $100,000. So that would violate the Seventh Amendment, and it's not permitted. All right. Let's see where we are. That's it. Trial, post-trial, and all of that. So I'm going to pause, and then we're going to move into into the Erie Doctrine.